My attention, Mr. Weinstein, you have filed a motion to recuse me. You have filed an affidavit consistent with that, pursuant to Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit, Baptiste versus the state. I invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay? As that, then transitioning to the last matter the court wanted to put on record, upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So
there's nothing more powerful than the odor of mendacity.
And welcome back inside the law. I'm your host, Philip Holloway. What a crazy week we are living in. Oh my gosh, where do we start? We have all sorts of political news. We have all sorts of just natural news. We've got Yellowstone Park. We've got whales sinking boats up in New England. But what better place to start than the Fani Willis versus Young Thug trial that we've all been following so closely right here in Atlanta, Georgia, because where are you going to get something that's more entertaining and just keeps you just on the edge of your seat more than this particular trial? What you saw just by way of recap, you saw Judge Earl Glanville, the Chief Justice of the Fulton County Superior Court. You saw him denying Doug Weinstein, our friend Doug's, motion to recuse himself following his improper meeting with prosecutors from Fani Willis' office in private, in secret, not with no awareness by the defense, not putting them on notice at all. We call that an improper ex parte proceeding, ex parte hearing he had in his office for upwards of a couple of hours, I think. So they filed a motion for him to recuse himself on that basis and other things. He denied it. And of course, then he carried on with the trial for a couple of weeks. But then the second clip that you saw was Judge Glanville reversing course. He decided that after immense pressure, I'm sure he wasn't watching inside the law, but he was probably getting some pressure from other places. And he decided to, of course, reverse himself. And he sent the case, the motion, if you will, to recuse, as the law prescribes, to another judge. And what happened when another judge took a look at the case and explored the law and the facts? Well, the other judge came up with this. The other judge was Judge Rachel Krause, and of course, she granted the motion to recuse Chief Judge Glanville, and she directed that the clerk of court reassign the case according to the local rules and procedures. It's called the wheel. It's not an actual wheel, but think of it like a roulette wheel. So the ball, if you will, lands on some random judge, right? And so in this particular case, now we have who do we have? We have Judge Paige Reese Whitaker of the Fulton County Superior Court. We're going to talk just a minute about Judge Whitaker. It's important to note that she wasn't the immediate next assigned judge. Another one was randomly assigned who recused herself because she felt that she had some reasons that she might be perceived as being not unbiased in the case. So she did what we want judges to do in that situation and to voluntarily recuse themselves. So now we have Judge Paige Reese Whitaker on the case. And before we take a look at who she is and what her background is, I wanted to say welcome to all of you who are here. As you have noticed, I am back inside the law in my normal, regular, customary digs. I'm no longer at the Fortress of Solitude, and I'm no longer at an undisclosed private location in a hidden bunker anywhere. So my travels, at least for the immediate future, have ended. So I am back. We are back in our regular sort of scenario, and we will be doing live streams as necessary. We're looking at not just this young thug case. We will be looking at any other legal cases that make the news, right? This is what we do here inside the law, is we use real court cases to bring you inside the real justice system so that you can learn what the real justice system is like. It's not the one that you think you might have if you just watch TV or watch the movies, but we use real court cases like this to see what we can learn, whether it's the good, the bad, or the ugly. So welcome to all of you who are here live and who may also watch this on replay. Thank you for being here. Thank you for liking hit that like button, and thank you for subscribing. I'm narrowing in on 50,000 subscribers. That's my next goal. So help me reach it. Tell your friends, tell your family, tell your neighbors, tell anybody who might have an interest in this type of subject matter about inside the law, so we can get to that magic 50,000 subscriber mark. All right, so let's take a closer look at Judge Whitaker. This is from the Fulton County actual website. You can see that she's been in her current judicial assignment since 2017. She got her law degree from Duke University in 1992. She got her bachelor's degree from the College of Charleston. Now, her professional experience, right at the very top, you see Deputy District Attorney Appeals Division, Fulton County District Attorney's Office. So that tells me right out of the gate that she probably has worked with, as an assistant prosecutor, Fani Willis, or if they didn't exactly work together, they certainly are no strangers, because a lot of people who wind up on the bench in Fulton County have served some time, and I say that almost like it's a jail sentence, but they've served some time prosecuting in Fulton County as well. But it wasn't limited to the Fulton County DA's office. She was a senior assistant attorney general in the Criminal Justice Division, the Georgia Department of Law. Of course, that's the Attorney General's office. She's had some leadership posts with the Georgia State Bar. She chaired the Georgia Commission on Family Violence, Georgia Women's Policy Institute, Leadership Academy, Georgia Association of Women Lawyers, treasurer for the Lawyers Club of Atlanta, executive committee, Old Warhorse Lawyers Club. Now, she doesn't exactly look like an old warhorse to me, but nevertheless, she was on the executive committee for the Old Warhorse Lawyers Club. She's a member of the Atlanta Bar Association, the Federalist Society, which a lot of people say if you're if you come up through the Federalist Society, you might be more conservative leaning. I just say that because I don't know if that really describes her or not. Judges are nonpartisan in Georgia, but some people see Federalist Society and they think, well, that's going to be a conservative judge. Past chair of the Fulton County Juvenile Court Citizens Review Committee, Pink Ribbon Story Foundation, and a sustainer for the Junior League of Atlanta. Well, there you have Judge Paige Whitaker. Obviously, we right out of the gate, we can tell that, we're almost, this is almost a brand new trial. It's just almost a completely new trial. And one thing that I want to share with you before we get into this motion for mistrial, I want to show you what we have right out of the gate here in terms of her courtroom expectations. And I got this, by the way, from Thugger Daily on X, and we will look in a moment at some of his Twitter feed, but he had this photo up here, and these are sort of a summary of how things are going to go now. Court will begin at 8:45 a.m. no matter what. If all defendants have any of their lawyers present, court's going to begin sharply at 8:45. That's a big change because Judge Glanville was notoriously late starting, and he took a lot of breaks and seemed to some people to be wasting a lot of time, particularly when you've got jurors that are making a whopping $25 a day while being torn from their daily lives. No more eating in court unless the day goes on longer than expected and they have to work through lunch or dinner. No more extensive wardrobes for the defendants. She's asking to minimize disruptions in court. Defendants cannot be using headphones during the trial, and no gaps between witnesses. In other words, the state needs to have their next witness ready and available when they finish with the current witness. These are kind of standard rules, by the way. This is not really something that it should be very surprising. Most of these things are rules that would apply automatically in every court throughout the United States on a day-to-day basis. But nevertheless, it looks like there's a new sheriff in town, or in this case, a new judge. And so we have new rules. All right. New judge, new rules. And of course, we have new motions. I want to see if I can pull up here a motion filed it's a motion for mistrial. Let me go ahead and share this screen with you. And this is our friend Doug Weinstein has filed this motion on behalf of his client, DeMonte Kendrick, a motion for a mistrial. Now, this is something that we knew was coming, and it's not going to be just this motion. It's going to be, I think, other defendants, of course, also filing their own motions. But if you can look at this one, I like how Doug starts out. He's quoting some really old law from 1824. Okay. We think that in all cases of this nature, the law has invested courts of justice with the authority to discharge a jury from giving any verdict whenever, in their opinion, taking all of the circumstances into consideration, there is a manifest necessity for the act or the ends of public justice would otherwise be defeated. They are to exercise a sound discretion on the subject, and it is impossible to define all of the circumstances which would render it proper to interfere. But after all, that means the courts, have the right to order the discharge, and the security which the public have for the faithful, sound, and conscientious exercise of this discretion rests, in this case, as in other cases, upon the responsibility of the judges under their oaths of office. So what's Doug saying here? He's saying here that, it's long been recognized, guys, that court's obligation is, the judge's job is to make sure that justice prevails, justice is done. And sometimes justice means terminating a case without sending it to the jury for a verdict. In other words, taking it away from the jury and saying, we're going to go ahead and end this, and we're going to end it now. Okay. So he's saying that, this is doing justice just as much as, a prosecutor aggressively, charging a case. Sometimes justice requires a mistrial. And if a mistrial is typically, if a defendant asks for a mistrial and if it's granted, then they typically can be tried again. But for reasons that we're going to discuss, This particular motion is asking for a different type of mistrial. He's asking for it to be dismissed with prejudice, meaning that it's done because the prosecutors, and in this case, they're going to allege Judge Glanville as well, caused it, and because they caused it, then these people could not be retried under the double jeopardy clause. He goes on to say the state has had witness after witness fail to provide the testimony that it would like for the jury to hear. Rarely in the history of Fulton County Superior Court has one party had to impeach so many of its own witnesses, including at least the following key witnesses. And the term here, impeachment, it's not like we're impeaching a president, for example. In this context, impeachment means you basically show the jury that your witness, what your witness is saying should not be believed. Okay. That seems very strange that you would impeach your own witness, but it is allowed. And in this case, they're saying that it's happened with the following key witnesses, at least. Trontavia Stevens, Walter Murphy, Archelian Bennett, Eduardo Nava Flores, Adrian Bean, D'Angelo White, and critically, Kenneth Copeland. Kenneth Copeland is, of course, the current witness who is on the stand. But in case you have forgotten, this is one of the individuals they are referring to.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lies.
Yes, you may. We're gonna take a break. Hang in there.
And here is an example of some testimony from Kenneth Copeland.
Text message.
I don't recall any conversation with Detective Thorpe.
I understand you can slow it down, but I'm gonna keep asking you these questions. So, do you recall texting or telling Detective Thorpe that another guy called you and said that those people were just lying?
I don't recall.
All right. So that's just an example. We've seen those clips before here inside the law. But I'm showing them to you because this is an example of the state's own witnesses basically not cooperating with them, and the state has had to impeach their own witnesses. In other words, explain to the jury that for certain reasons, the jury should not believe what their own witness may have just said. Okay. So moving along, what else does this motion say? It says, what is the state to do? Losing its case, apparently unconcerned about the need for public justice. By the way, the prosecutor's main job, their main job in any case is to do public justice, whatever that might mean. And it might mean dismissing a case, but it certainly means when you prosecute a case, you do it fairly and within the rules of law. The state clearly sought an opportunity to restart the trial by triggering an event in such egregious violation of the constitutional rights of Kendrick that he would have no choice but to request a mistrial. Well, what's Doug talking about? He goes on to say, now goaded by the state and the actions of Judge Glanville, Kendrick has no option but to move for a mistrial to respect the rights of Kendrick. And so when he uses this word goaded, Goaded, that word has legal significance. In other words, if a defendant asks for a mistrial, normally there can be a retrial. But if you are goaded by the state, and in this case, they're saying the state and the now former judge, if you're goaded into doing it because you don't have any other choice because they've done something so egregious, if the mistrial is granted under these circumstances, double jeopardy prohibits a retrial. He goes on to say, while this trial has been riddled with scores of errors, at least 3 demand an immediate mistrial. And I'm glad that he's limiting this to 3 because there are so many. that we would be here for hours and hours talking about the things that could lead to a mistrial. First, placed in an impossible position by the state, the court is faced with the task and requirement to reset this case to at least the point the afternoon of June 12th, 2024, when Kendrick moved Chief Judge Glanville to recuse himself, and he improperly failed to halt the proceedings. And what the law requires, folks, just by way of refresher, when the defense files, or any party files a proper motion to recuse a judge, then the judge must stop the trial and immediately refer the case over. And as we saw, Judge Glanville didn't do that. The videos, clips that we showed here at the beginning of this live stream, Judge Glanville, at first he said no, he's going to deny the motion, but then like 2 weeks later, he decided he was going to go ahead and do a 180 and reverse himself. And then he did send the case to another judge for consideration, who of course ultimately removed him. And so what you have is this situation where, because he didn't follow the law, you had proceedings, you had things take place during that interim period before Judge Glanville did his 180. And so what Doug is saying in his motion here is that you got to figure out how to reset this case to the afternoon of June 12th, when Judge Glanville should have done the right thing the first time. The second reason that he claims is a mistrial, constitutional rights were violated when neither he nor he being his client, nor his attorneys were present at a critical stage of the proceedings. And by the way, that's also a phrase of legal significance. The Sixth Amendment says you have a right to counsel at all critical stages of the proceedings. Some things are not considered critical stages, but most things after a jury is impaneled, pretty much everything is considered critical stage. In this case, he's referring to the secret ex parte one-sided meeting among the state Chief Judge Glanville, witness Copeland, state investigators, court staff, and deputies. That's the now infamous ex parte proceeding. All right. And the third ground that Doug claims here, he says due process rights were violated when Glanville wrongly coerced Copeland to testify. None of these reasons for mistrial would exist absent the state's intention to goad Kendrick into the unfortunate position of having to request a mistrial. And he goes into the background, some of the things we've been talking about. But he points out this case began nearly 18 months ago. Jury selection took more than 10 months before a jury was finally seated in November of 2023. A secret ex parte proceeding was held on June 10th, 2024. In attendance were Chief Judge Glanville, witness Kenneth Copeland, who had been sworn and was currently the witness on the stand, so to speak, the prosecutors in the case, Love and Hilton, and certain investigators from the DA's office, court staff, members of the Fulton Sheriff's Office. A central figure, perhaps the central figure in the state's case against Kendrick and the other defendants, is Mr. Kenneth Copeland. It says on Friday, June 7th, he was sworn in after being given a grant of immunity. Now, for those of you who might not remember what happened that day when he was sworn in, here's what happened.
See, our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
All right, so Copeland was granted some type of immunity from the state, but he was not given immunity for any federal crimes that he might testify to. So he and his lawyer apparently decided that it was in his best interest to take the fifth. And so that's what he did. Well, he went to jail. Fast forward to the following Monday morning, you have this secret ex parte meeting happening in Judge Glanville's chambers. And among other things, they threatened him with holding him in contempt and throwing him in jail until not just this trial is over, but until the trial of all the defendants. And remember, there's about a couple of dozen others that are not part of this trial that are named defendants in this indictment. All right, so this is what Doug is saying here. On June 7th, Copeland was sworn in after being given a grant of immunity, being warned by Glanville that incarceration would be the result of refusing to testify. He continued to plead the fifth, was held in contempt, as we just saw. Glanville said, we'll all be back on Monday morning and we'll see where things are. Well, unbeknownst to any member of the defense counsel, excuse me, this secret ex parte proceedings was held in Chief Judge Glanville's chambers on that date. Among the attendees were Glanville, Love, Hilton, ADA Hilton, that is, and investigators from the Fulton DA's office, deputies, witness Copeland, and court staff, and also attorney Kayla Bumpus, who was one of the attorneys representing Mr. Copeland. No member of the defense was present, and nobody was notified about it. Judge Glanville nor any court staff, nobody else was aware that this was even going to happen before, during, or after. Several defense counsel were later made aware of the ex parte proceeding, and then all hell breaks loose. Okay, so Copeland eventually decided that he would rather than sit in jail for 2 years, he would testify. Glanville told Copeland that Glanville could keep witness Copeland in jail until all defendants were tried. Copeland was informed that there were over a dozen defendants left to try. Following the above coercive actions by Glanville, working in concert with the state, then he decided he'd go ahead and he would testify. So Glanville also presented Copeland with a printout of Georgia's perjury statute, as well as the false statement statute, and explained that those were felonies and that he could be prosecuted. Copeland informed, apparently, the court and the prosecutors he would lie on the stand. Now, that is something called Brady material. Brady materials in exculpatory information that defendants are absolutely entitled to. And so to keep that information from the defendants was absolute, in my opinion, reversible error, and it's grounds for a mistrial on its own. But you've got to turn over any what we call Brady or exculpatory material. That's due process, federal constitutional law, pretty much black letter law at this point. It's very well settled. The state never gave Kendrick these critical Brady materials. These troubling facts, and troubling is too nice of a word. They're just really egregious. I can't begin to tell you how improper that was. And I'm scratching my head. I still can't believe that this even happened, as often as we've talked about it. These facts implicate Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, and also demonstrate an illicit effort to repress this Brady material that I was just talking about that should have been provided to all the defendants. All right. So Doug goes, it's all more of the same. And he points out that mistrial is required as to all proceedings. Mistrial is required as all proceedings. Everything that happened after June 12th is void. The court is faced with the impossible task of rewinding the case to the afternoon of June 12th, 2024. This is when Judge Glanville failed to pause the proceedings and failed to do what he was required to do, which is to send the case, the motion, to another judge, because you can't grade your own papers. Another judge is supposed to rule on it. He finds some case law here. It says if a party files a motion to recuse, a trial judge and the motion is denied, but it's later determined that the judge should have been disqualified, then all proceedings after the filing of the motion to recuse are invalid and of no effect. Well, how are you going to undo things that happen like this in the presence of a jury. It's just impossible. Kendrick moved the judge to recuse himself on the afternoon of June 12th, and he denied that motion. He failed to follow the uniform rules of court by not halting the proceedings and sending the recusal to another judge to rule on it. Therefore, under the law that he just cited, all proceedings since that afternoon should be invalid and have no effect. Now, this court is saddled with the repercussions of Judge Glanville's failure to follow the law. He should have halted the proceedings, but he didn't. He goes on to point out this court is tasked with unringing the bell. Okay. So what happened in that interim period? During that time, Glanville, who should have been disqualified, repeatedly ruled against Kendrick and other defendants on multiple objections regarding the questioning of Copeland. Under repeated objections from Kendrick and other counsel, the tainted testimony of Copeland was presented to the jury over the course of 4 days, and the remainder of the day on June 12th and 13th, 14th, and 17th. And all of those relevant times, Glanville should have been disqualified. Okay, so these are things that happened that should not have happened. It's just incredible to me that this whole thing has gotten to this point. Instructing, this, I like this language here. This is very creative. Instructing someone not to picture flying elephants only results in the listener conjuring up images of Dumbo. In other words, if you tell a jury, if you say, look, ladies and gentlemen of the jury, you've got to disregard everything that happened during this period of time. So that's what the state's going to say they should do. They should say, look, you just give the jury what we call a curative instruction, tell them to ignore everything that happened. But as Doug points out, instructing someone not to picture flying elephants only results in the listener conjuring up images of Dumbo. And so given the impossibility of erasing the proceedings that are void, this honorable court has no alternative but to declare a mistrial. And I agree. And I completely agree with him. So we won't go through the rest of it because that's the key parts of this. That is the gravamen of all of this. It all boils down to Judge Glanville doing something that he should not have done. There's just no way to unwind that. Now, I see we've got a very active chat. Thank you all for being here. We now have 600 or so people here in the live chat. Thank you for joining us here inside the law. We are taking a look at the latest motions filed now that we have a new judge in the Young Thug trial here in Atlanta. The other motion that I want to get into with you is I want to, if I can find the right one here, I want to pull up here it is. The state has filed a motion for a gag order, right? So here we have something that Georgia law does not like. In Georgia, gag orders are presumptively unconstitutional, okay? They are presumptively unconstitutional. Now, this drops later in the day, and I have not had a chance really to look through it much, but it's not a long one. So we can go through it together, okay? State's motion to restrict what they're calling extrajudicial statements. And they cite Georgia rules of professional conduct prohibit lawyers from making extrajudicial statements that a reasonable person would believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Well, guess what? The ladies and gentlemen of the jury have been instructed, and they are presumed to be following all instructions. They've been instructed not to read anything about the case. They've been instructed not to watch YouTube channels like this. They've been instructed not to watch the news about the case. And so if they're following the judge's instructions, nothing that any lawyer says at this point outside of the courtroom should even reach their ears, theoretically. So they are going on. They point out that defense counsel have made numerous extrajudicial statements explicitly about this case. And look, Doug Weinstein has been here inside the law, and I'm sure he'll be back. But he's been here talking about his motions and about this case and about Judge Glanville and about the ex parte. Go back and look at some of those former or prior videos. You'll see exactly what Doug's had to say about it. They talk about these lawyers and attorney Max Shart have all made extrajudicial statements to the media explicitly discussing the case. And they allege that it's in violation of Rule 3.6, but I say it's not in violation of Rule 3.6 because the jurors are not supposed to be watching what happens. They're not supposed to be looking at these things. The exhibits that they attach here, here's Exhibit A. It says Brian Steele's statement regarding the recusal order. Jeffrey Williams is innocent of the charges brought in this indictment, and to clear his name, he sought a speedy trial, one in which he would receive constitutional guarantees of a fair trial with an impartial judge, as long with ethical prosecutors following the law. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under the law. Mr. Williams is grateful that the reviewing court agreed with him and entered the order recusing and disqualifying Judge Glanville from presiding over Williams' case. We look forward to proceeding with a trial judge who will fairly and faithfully follow the law. What is Exhibit B? They give a link to a YouTube video where it's called The Exclusive Young Thug's Attorney Speaks Out on Glanville Recusal. It's not Brian Steele, that's his other attorney, Keith Adams. And they give a Exhibit C, and this is the Associated Press reached out to Glanville and to a lawyer for Young Thug seeking comment. He says, while I respect Chief Judge Glanville and his service to the community and the country, he simply became biased over the course of this case. Kendrick's lawyer, Doug Weinstein, said in an email. He added that he looks forward to trying the case before an unbiased judge, but said the only just outcome at this point is a mistrial and a bond for Kendrick, who has been jailed for more than 2 years. Exhibit D, another YouTube video where Doug Weinstein discussed the case with journalist Megan Cuniff. When I was looking at this, guys, I thought maybe they were going to cite Inside the Law, but they didn't. They got Max Shart interviewing as well. Let's see. Megan interviews defense attorney Max Shart. Another YouTube video. The debrief with attorney Doug Weinstein. Another YouTube video that he's done. And so those are the instances the state is citing where they're saying that, the defense lawyers have made these extrajudicial statements to the point that they violated the rules of professional conduct. And so a gag order is necessary. So under Georgia law, gag orders are presumably unconstitutional. It violates the First Amendment. And when you've got instructions already in place that tell these people on the jury that they're not supposed to be looking at any of this stuff anyway, presumably they are following the judge's instructions. And so if you've got the protections of the instructions, then it's entirely reasonable, I think, for the attorneys to come on YouTube or the local news or to do a spaces on X or whatever they're doing and to discuss the case. That's the First Amendment in action. Sorry, ADA love, but I think that motion should be a loser, but we'll just have to wait and see. We'll have to wait and see what happens. All right. We're 40 minutes in. I've just been talking. You've been hearing me. I want to see if there's any of you all that have any questions. I'm sure you have, but I've not been able to be watching the live stream. But I do see some questions. For example, Colleen asks, are jurors ever sent to jail for violating the rules? Well, occasionally. Yeah, I've seen it happen. I've seen it threatened. It's not common, but it does happen. Sometimes jurors do get in trouble with courts for violating various rules. So sometimes that does happen. So thank you, Colleen, for that question. If anybody who has any other questions, please feel free to mention them here in the chat. There's a question here. Why is there no recusal? So that there has been a motion filed to recuse the two prosecutors. That is also pending. And I don't know if or when there's going to be a hearing on it. But one thing I meant to mention earlier that I should point out, I would anticipate there's going to be an evidentiary hearing where we might hear testimony. We should hear testimony from Judge Glanville. We should hear testimony from the two prosecutors, because there's got to be an evidentiary record made about this ex parte. Okay. There's a transcript that Judge Glanville had ordered released, but there's questions about whether that transcript is complete. In other words, was there more that happened that did not make its way into the transcript? So these are all great questions that deserve answers. And the only way to get answers is to bring the people in under oath and question them about why they were doing it. Whose idea was it? What did you think the justification was for doing it? What was said? Who said it? Who asked what questions, and who answered other questions, and what else happened? Okay. And so you got to ask Glanville. You got to ask both prosecutors. You got to ask the sheriff's deputies that were back there. You may need to ask the court reporter as well. Madam Court Reporter, were you ever instructed by Judge Glanville to take something out or to go off the record for any particular reason? And if so, what happened during that off the record period? If you were off the record, was there nevertheless an audio recording made of it, so that we can at least know what happened during any off the record portion? So there's a lot that we need to find out. So there's going to be some evidentiary hearings, obviously, and that's part of the motions to recuse the prosecutors as well. Why isn't Adrienne Love removed from the case? Well, I think I just kind of answered that question. She might yet be. It might happen. We're just going to have to wait and see if the judge is going to have an evidentiary hearing on that. Don't all these rules apply to Woody too? Well, yeah, the witnesses are instructed not to discuss their testimony once they leave the stand. In other words, once a witness is testifying, and technically Woody is still the witness on the stand, even though they might be in recess, his testimony has begun and it is not yet concluded. Witnesses are instructed that they are not supposed to discuss their testimony outside of court, and it's my understanding those instructions were given to him as well. Good question. Does the gag order apply to Fani Willis in public? Well, look, if the judge grants a gag order, the one asked for by the prosecutors in this case, and I hope she doesn't, presumably she won't, but if she does, probably it would apply to the prosecutors as well. I can't imagine that it would be a one-sided order, gag order. All right. Let's see. I know I had some other questions back here, and I saw them, and the chat was going so fast that I missed some of them. But if I miss your question tonight, and if you think of something that you want to ask it in the comments. Even after the live stream ends, you can ask questions. And one thing I like to do is I like to go in and I will rewatch the live chat so I can see what I missed on the replay. I can see what I missed when we were doing it live, and I also will do my best to try to answer questions that are posed in the questions and comments on the replay video as well. Teresa asked, didn't Fani Willis attempt to block the new law to investigate the DA's office? So I think what this is regarding is there is a new agency that was created by the state legislature. We have the Judicial Qualifications Commission, which is the watchdog entity that governs how judges, make sure they follow the rules. There's a similar body that was created by the legislature that is supposed to sort of police how prosecutors do their job. And yes, Fani Willis did oppose it. Nevertheless, that law did take effect. Good question. Thanks for the question. All right. The only one that is supposed to have a gag order is prosecution. Well, prosecutors do have certain built-in restrictions that apply to them for making extrajudicial statements. But as of right now, there is no gag order per se in this case. This is off topic, but it's a good question. If you're referring to the Trump trial in Georgia, we have discussed the Fani Willis versus Donald Trump and others, the RICO case, a lot here inside the law. Right now, there's not been a lot happening, but it's worth pointing out that we have this big whole thing about whether or not Fani Willis is to be removed from the case due to her conflict of interest and due to her own extrajudicial comments, things that she's done outside the courtroom that's called forensic misconduct. There's going to be oral argument, but it's not going to be until December. I think it's December the 5th. So it's after the presidential election, and the ruling from the Court of Appeals would be expected, 2 or 3 or 4 months after that. So we're not going to have any ruling on it before the election, but for the time being, that case is fairly well stalled out. I think it's very much fair to say. All right, got time for a couple more questions. Will that issue go away if a mistrial is declared? I don't know, Kate, what issue you're talking about, but if a mistrial is declared, then the case is going to be over and they won't be able to retry these people. So all of the issues that they are saying, things that they're complaining of that have gone wrong would become moot because the case would be ended. This is a fair point. It says, I'm sadly mistaken if I think for 1 second the jurors have not seen or watched anything. I'm not I'm not naive enough to think that they haven't, or that jurors don't sometimes break those rules. But what I'm saying is they are presumed to follow the rules. So if the jurors are presumed to have followed those instructions and listened to the instructions and done what they are told, then that would weigh against the necessity for the gag order. But very good point. Thank you for making it. Is Brian Steele still pursuing, looks like deposing Love? Yeah, he wants to, it's not a deposition. He wants to get them in court, in open court, and ask them questions under oath. So that would be part of any, I think, motion for any hearing on these motions for mistrial, I think should include questioning of those individuals. And also Judge Glanville, by the way, he needs to get under oath and he needs to answer questions as well. And quite frankly, I think he needs a lawyer. I think he needs a lawyer because I think he's done some things that really could cost him his job. And maybe he needs to take the fifth if he's ever subpoenaed. But that's just my opinion. I think that this ex parte was so bad. I think it was so egregious. This is the kind of thing that the Judicial Qualifications Commission, to say that they frown upon it is an understatement. But nevertheless, I think it's worth pursuing getting all those individuals in court under oath. All right. That's about what we've got for tonight. I've got weather moving in, and I'm afraid it's going to impact my internet connection here in the very near future, perhaps just a few minutes. I want to thank all of you for being here inside the law. And remember to hit the like button and subscribe, and Remember, help me get to the 50,000 subscriber mark. Please tell your friends, your family, your neighbors, anybody who might be interested in this kind of subject matter, that this is the place to come if you want to learn about the real justice system, not just the one that people might think we have, but the one that we really have. We use cases that are in the news, cases that are current events to illustrate these points. So I want to thank everybody for being here watching live. Thank you for joining the chat. And of course, thank you as well for all of you who join us on the replay. Until next time, we'll see you right back here inside the law.